Got some breaking news that's coming in at this point. There is no error in the earlier May 2017 judgment. There is therefore no scope for review. This is while dismissing the review plea of Nirbhaya's rapists, is what the Supreme Court said, that there is no error in the judgment, in the May 2017 judgment, and therefore there is no scope for review. Those are the details that we're getting. Let's go back to Meenakshi, who's with us. Meenakshi, take us through this breaking news that's coming in now.
Well, Urvashi, this is a reaffirmation of what we have been showcasing on Mirror Now since morning. We have been talking about the difficulty that the Supreme Court would find itself in if it, even for a minuscule percentage of chance, went ahead and, reviewed or reconsidered its earlier judgment. Given the fact that the May 2017 judgment was exceedingly well written, it was very explicit, and one critical thing which has clinched it for the Nirbhaya rapists and convicts has been the dying declaration of Nirbhaya herself. The Supreme Court in its May judgment had said that particular declaration of Nirbhaya is unimpeachable. It had relied heavily on it, and our viewers will recall it was Nirbhaya who had recorded her statement, which eventually went on to attain the proportion of a dying declaration subsequent to her passing away before a magistrate. So that has a lot of criticality. It is of such prominence in the eyes of law because remember, the Supreme Court also went on to add as to how the brutality, the diabolical nature of this crime was something which caused a breakdown or a devastation of social trust in the society. Supreme Court relied heavily on the aspects of the physical brutality, on the bite marks on her breast, about the fact as to how the rod was inserted in a private part which caused sepsis. And thereupon, the Supreme Court also observed as to how the brutality of this act completely showcased as to how these rapists were only interested in ravishing her for their sadistic pleasure. And then it was Honorable Justice Bhanumati Urvashi who had said that if this case does not deserve the death penalty, she would wonder which case does. So those were the findings. So for the defense counsels to now take the plea that it has been something which has been manipulated as a result of media pressure, political pressure, is completely unfounded, really, given the fact that it was dying Nirbhaya herself who recorded her statement before a magistrate, completely detailing all that happened to her in that fateful wintry night of December, Urvashi. And that is what really has clinched this case. And just moments back, the Supreme Court coming out with the details as to why it is dismissing the review, which is essentially a reconsideration for the Supreme Court to intervene to try and get the court to overturn its earlier findings, and the court categorically in its finding that there is apparently no error in the earlier judgment for the Supreme Court to intervene or sort of like overhaul its earlier judgment, and therefore there is no scope for a review or a reconsideration, because of which the Supreme Court has just gone ahead and dismissed these convicts and rapists review plea, which was seeking for the Supreme Court's intervention. So big news we have heard from the parents of Nirbhaya. We have also heard from defense counsel, still trying to really maintain some semblance of an argument in spite of overwhelming material evidence, in spite of overwhelming opinion of the Supreme Court. They're still trying to weave a narrative to somehow manage to get some elbow space, but that clearly is not happening. This is one step closer, as we have been showcasing on Mirror Now, Urvashi, towards the execution of the death penalty, which eventually will be, because they have two more recourses that they can take. They can file a curative, and then they can subsequently go on to file a mercy plea before the President of India. Urvashi.
All right, Meenakshi, thanks for getting us those details. Stay with us. I'll also go across to Viren, who's joining in right now to take us through the entire timeline of events ever since this happened. Viren, over to you. Take us through the entire timeline of the sequence of events that have happened.
Well, it's Avni, it's taken 6 long years for us to reach, nearly 6 long years, in fact, to reach this position where the Supreme Court has now dismissed the review petition that was filed by 3 of those convicts. Remember, one of those was a juvenile who then served 3 years in a juvenile home, after which he was released as per the law. Now, this case, of course, Avni, had larger ramifications for the country as a whole and for rape laws as well. And that had set in motion, of course, a tightening of the manner in which these sorts of cases were being dealt with. Because of that, now we've seen, in many cases, fast-track courts being set up to try and tackle these cases in many parts of the country to deal with the problem. But unfortunately, I think the numbers speak for themselves. The cases of rape have not gone down. In fact, they have been going up. And now we're in July 2018, where the review petition has now been dismissed, as Meenakshi rightly pointed out.
Viren, if I can interrupt you, I think we're getting some more reactions. Let's cut across.
Should have been understood and almost known. So I think I don't think that anything which needed to happen has not happened. What should have been done in the proper course of justice and to establish the rule of law was the inevitable part to dismiss the review petition.
And Supreme Court also said there's no ground for reviewing it.
Naturally, what was the ground of review? How can you always try to utilize review as a tool to almost try to reopen a judgment? When the judgment has been given with such detail and with such brilliant judgments, considering all the facts and circumstances, the chain of all events having been completed, as I mentioned, beyond reasonable doubt, everything having been established, there was no other logical corollary to this situation but to have the conviction and, in such a gruesome case, to have the death sentence.
Now the convicted counsel are making some media statements, and there was media trial, political pressure on the Supreme Court. Was this
I find this very surprising. How can there be any question of any media trial in this? How can there be any question of any political pressure in a case which involves rape, and that also a brutal rape of a girl in such a situation in South Delhi? I think sometimes people just make statements without responsibility. It is not a case which warranted or which could have had any kind of political pressure, which could have had any kind of media trial. This is a case which is established on its own facts and on its very brutal and gruesome facts.
But many years are passing now. Don't you think if justice is getting delayed, implementation is not done? I think legal options still they have president and curative petition.
See, we have, as far as India is concerned, we have retained the death penalty and we have upheld the constitutionality of it, but subject to the various conditions and subject to the rights of the accused to have every possible rule of law and every possible avenue and access to justice. So I think we should not short-circuit any process, and our anxiety sometimes to expedite situation should not in any manner result in deprivation of the legitimate rights of the accused.